Representative Crago,
Excused.
Representative Chestick,
Here.
Representative Harrelson. Representative Jennings, Representative Nemec,
Here.
Representative Oakley. Here. Representative Provenza,
Here.
Representative Rodriguez Williams,
Here.
and Chairman Washut is excused.
Excused.
Thank you.
Thank you. Good morning, everybody. Welcome to House Judiciary Committee. We have several bills, looks like 4, and potentially some online testimony as well. And so just a friendly reminder to those that are testifying to address the chair, state your name, and we will go ahead and get started. It's 8:03. I think our first bill is going to be Senate File 55, and we have Senator Nethercott here with us today to introduce us to the bill.
Good morning, Madam Chair. Good to be with you, House Judiciary Committee. You have in front of you Senate File 55, which is an extension of the Chancery Court term. As you all may recall, in 2019, the legislature passed Chancery Court. Is that better? I think it is. And so we created a Chancery Court, which is really important to Wyoming's economic picture, both as it comes to the legal field and then it comes to attracting new businesses to our state. And so that was an impetus for putting that in place in 19. In December of 2021, the court became operational. It is a fully online court and with an entirely different set of rules associated with it, separate and apart from our district courts or circuit courts in our state. From December 21 to now, there's approximately 16 active cases that have been filed in the Chancery Court. As a result of understanding that that docket and the workload associated with it doesn't justify its own judge to preside over it with the salary and staff, what the courts have done is to allow for the district court judges to volunteer their time, the current sitting on the bench district court judges, to volunteer their time to serve and preside over those courts. And so they would like to continue to do that. And so there's an extension of fully funding the courts and the Chancery Court with its own judge for another year in light of that. So this is a cost saver and a very prudent response. The reason why it's only 1 year is we do anticipate that the docket load will continue to exponentially increase as we've seen it occur so far. And so it's probable or possible that in another year from now, it will require its own judge to preside over. And so we'll just evaluate it at that time, requiring legislative oversight over that process and whether or not that is necessitated at that time. But this is it. Looking at the data associated with the workload associated with the court, it is on track and consistent with other Chancery courts and their creation for seeing how they have grown in time. And so all is good and all is working as intended, and that's a positive sign. So with that, I'm happy to stand for questions.
Any questions from the committee? Representative Jennings.
Well, thank you, Madam Chair Lady. So Senator Nethercott, good to see you again. So how much money does this save us?
Mr. Chairman, it would save the cost of a full-time judge, staff, and court reporter. So approximately, I'm going to say about approximately $350,000 annually.
Follow up? Additional questions? Seeing none. Do we have any departments or agencies that would like to come forward and testify on the bill? Welcome. Just please state your name.
Good morning, Madam Chair. My name is Elisa Butler. I am the State Court Administrator for the Wyoming Judicial Branch. And I would just like to say we support this bill. Currently, there is not a big enough workload to have a full-time sitting judge. We anticipate there will be in the future, but this gives us a little more time and saves the state some money in the meantime. Thank you.
Thank you, Ms. Butler. Any questions from the committee for Ms. Butler? Seeing none. Any additional public testimony on the bill? Anybody online? No. Okay. We're going to go ahead and close public comment and committee, what is your pleasure? Moved by Representative Oakley, second by Representative Provenza. Discussion, amendments. Question being called. Roll call.
Representative Cragel,
We have an absentee vote of aye.
Representative Chestick,
Aye.
Representative Harrelson. Representative Jennings. Representative Nemec,
Aye.
Representative Oakley.
Aye.
Representative Provenza,
Aye.
Representative Washut,
Absentee vote of aye.
and Vice Chair Rodriguez Williams.
Aye. That passes. Senate File 55 passes. You have another. Okay, we'll go ahead and move on to Senate File 69. Work. Electronic records retention. If you go ahead and introduce the bill to us.
Thank you, Madam Chairman. You have before you Senate File 69, electronic records retention. Good representatives, what this bill does is it advances the judicial branch and its record keeping from microfiche to digitized record keeping. That's the bill. Happy to stand for questions.
Any questions for Senator Nethercott? Representative Haroldson.
Thank you very much, Madam Chairwoman. Senator Nethercott. So is there, I didn't see a fiscal note. So obviously, if we're going from microfilm to scanning and digitalizing, is that are we having to add positions, or is this a position already in place? We're just changing process and policy. Is this just a deal of, hey, we're in the 21st century and we ought to look like it?
Senator Nethercott.
Thank you, Madam Chairman. There is no fiscal note, so the court is not asking for additional money or positions for this. I think in many ways, likely this is already occurring. Just want to be in line with statute. Probably costs more to try to microfiche something in light of the unavailability of that technology. So this is just keeping that, that practice consistent with statute.
Any additional questions?
Yeah.
Representative Jennings.
And Chair Lady, Senator Nethercott. So we've been doing this with the courts of trying to update them for, well, as long as I've been here. So why this? Why do we have to have the legislation to do this? It seems like it's probably already, like you said, it's already being done. And who knows, maybe microfiche will come back.
Senator Nethercott.
Madam Chairman, Representative Jennings, well, it's my observation that the legislature many moons ago in enacting Wyoming Statute 57103 decided to control the courts in how they would retain their records, feeling the need to specify in statute the manner and method of which those records would be retained, which is why you see on page 2, line 12, microfilming. And so that is, I think, an example or a lesson of how maybe when the legislature becomes too prescriptive, it doesn't necessarily reflect what's currently going on in time, thus necessitating the need to update statutes with bills to allow for current technology uses or practices. that just makes sense, as opposed to just a directive from the legislature that records shall be retained in a manner that allows the public access to them. We have decided to be that prescriptive. And here we are, probably 25 years later, updating it. And so do we need it now? The answer is yes. The court wants to be in compliance with the law. The statute currently requires microfilming. They're not microfilming anymore. State Archives likely doesn't want to microfilm anymore and instead allows for the scanning and digitizing of those records. So they do want to be compliant with state statute. So we do need to change it.
Follow up?
Yeah, Senator, thank you, Mr. Chair Lady. 12, starting on 11 says nothing in this section shall limit or prohibit. So it seems like that they weren't prescribing to them that they had to do microfilming in the first place.
Senator Nethercott.
Madam Chairman, there's a requirement that those records be retained, which is another section of statute. So all public records have to be retained forever in perpetuity, particularly court records. The court holds onto them for a period of time before they go to the Wyoming State Archives, where you can pull up records from 100 years ago or longer in our courts. So this deals with that section addressing microfilming, updating it to scanning or digitizing. As you can see on line 14, it also gives some discretion for rule of the Supreme Court to further provide flexibility associated with the retention of these records.
Follow up?
Yeah, thank you.
Representative Jennings.
Thank you, Chair. So when I'm reading this, 13 and 14 disposing of the originals, and then you're striking that particular, what happens to the originals?
Senator Nethercott.
Madam Chairman, my understanding is the originals go to Wyoming State Archives. Of course, originals are in paper form, or at least they are currently or historically have been as we go into the digital age. And court filings are done electronically, as in the Chancery Court. There is no paper original. So we're kind of walking in two worlds, one the historical world of paper and one the digital world of electronic filings. And so knowing that we need to either continue to buy office buildings or storage units for keeping hundreds of years of paper, if not longer, which it does not last. I'm not sure there's a need to keep those in a museum somewhere with whatever best practices for museums for keeping paper forever. Does allow for those original paper versions to be destroyed so long as there is an accurate record of what those documents say. And we're talking about normal court filings, so kind of the run-of-the-mill pleadings that are filed with the court, not historical significant court filings.
Follow up? Representative Chastain.
Thank you, Madam Chairman. Senator Nethercott, I appreciate that there's another statute that requires retention of records. I'm just concerned that there's a deletion on line 16 that might create some ambiguity, and it might be better to simply eliminate the ambiguity by restoring the words official microfilm. Because it's kind of hard to follow how, because this sentence kind of reverses on itself several times, but by striking out official microfilm, it looks like this gives the court records people permission to dispose of the official microfilm, which is in conflict with the other statute. And if we simply eliminate the words official microfilm, you can retain, you're allowed to retain the official microfilm. If you take that out, there's implied permission that you can destroy, get rid of the official microfilm. That's my concern. But I see nothing wrong with retaining the existing microfilm. There's no requirement to continue making new microfilms. And the prior on line 12, 11 and 12, but at least let's keep the old ones.
Madam Chairman,
Senator Nethercott.
Representative Chestick, I don't think that's what it says. It does not require the destruction of the microfilm records. It doesn't authorize it or not authorize it. I think, again, kind of using some of the common sense associated with this update of the statute, recognizing that microfilm also will not last forever, nor will the technology associated with viewing it, that when it is appropriate, when there is manpower and resources, that those records that are currently maintained in microfilm will be transferred to digital, but there's no order of destruction for microfilm.
Follow up?
Yes, thank you, Madam Chairman. I agree that there's no requirement to destroy, but there could be implied permission to destroy. That's what I'm, I think it's simple fix to simply restore the words official microfilms, so you may retain them. And
Senator Nethercott.
Madam Chairman, Representative Chestick, this bill draft came to me from the courts and the clerks. I actually didn't make this one up. And so trusting their wisdom and looking at this issue and wanting to modernize it, I feel confident in this proposed language that they currently possess or that they've provided. And so, I'll leave that up to you. I don't want to overcomplicate the bill. It is as simple as I originally presented it. So with that, I'll trust your wisdom.
Additional questions? Chairman Washut.
Thank you, Madam Vice Chair. As I read that same line, the official microfilm digitized or imaged records in a case management system. There's no way in a computerized case management system to incorporate microfilm. If we reinsert the language microfilm, it's an impossibility because the case management system is a computerized system. So there's no way. Would you agree with that? That you can't put physical film into a digital computer?
Senator Nethercott.
Madam Chairman, at risk of guessing, I think you can print microfilm. I think you could probably also take digital image of the microfilm image and place it in there. But again, I will leave that up to the geeks.
Follow up, Chairman Washut.
Thank you. And then on line 14 above, we give the Supreme Court rulemaking authority. They're going to address all this. Isn't that your expectation?
Senator Nethercott.
Madam Chairman, it is my expectation that rulemaking authority provides a little bit more flexibility than what's currently in statute.
Additional questions for Senator Nethercott? Seeing none. Okay, is there any agencies or department heads that would like to come forward and testify on the bill?
Good morning, Madam Vice Chair, Mr. Chairman. Again, my name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. And as Senator Nethercott explained, the intent of this bill really is to alleviate some burdens on the clerks as we move to e-filing. When you go to e-filing, there is no paper record. It doesn't exist. What happens is attorneys can draft their pleadings and then upload them into the e-filing system, and they are transmitted into the case management system, which is what the clerks use to track their records. It's all digital. And so this really is intended to alleviate the burden on the clerks to maintain both a paper record and a digital record, and to alleviate the burden maybe of archives when all of those documents go to archives to have to microfilm paper records. So really that's the intent. I'd be happy to answer any questions.
Any questions from the committee for Ms. Butler? Seeing none, thank you, Ms. Butler.
Thank you.
Any additional testimony? Okay, do we have any online? Okay. Seeing that, we will close public comment. Committee, what is your pleasure? Moved by Representative Haroldson, seconded by Chairman Washut. Any amendments? Discussion?
Question.
Question being called. Go ahead and take roll call.
Representative Craigo,
We have an absentee vote of aye.
Representative Chestick,
Aye.
Representative Haroldson. Representative Jennings, Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Chairman Washut,
Aye.
Vice Chairman Rodriguez Williams.
Aye.
We have a total of 9 ayes.
So House Senate File 69 has passed. And we'll go ahead and take your last bill, Senator Nethercott, which is Senate File 91, Creation of Tenancy by the Entirety. If you want to go ahead and introduce this to your bill.
Thank you, Madam Chairman. Appreciate the flexibility in the agenda. Senate File 91, creation of tenancy by the entirety. Good representatives. Tenancy by the entirety is a form of property ownership, meaning that you can own property with another person and you own that property entirely together. Typically, you see this, you likely own your property with tenancy by the entirety with your spouse. And the deed looks something like this. John and Susie Smith as husband and wife own the following described property with the address. And then that's filed in real property records. And so what's the significance of that language, husband and wife? Why is that there in a deed? And so historically in Wyoming, both across the country and in Wyoming historically, that has been mean to suggest that John and Susie Smith own that property as tenancy by the entirety. And so if one spouse dies, the other spouse receives that property entirely. That is distinguished from different types of property ownership. Let's say John and his brother Jim own property together, and it says John Smith and Jim Smith own the following described property. Now, if one of them dies, how is that property held? Does the brother get the property entirely or not? And it depends how they purchase that land and how that deed is spelled out to identify how that goes. If there's nothing prescribing how that property is held, then typically the court and the law will interpret that as being the brother owns a half an interest essentially, and then the deceased brother's descendants own the other half. That's called tenants in common. And that's generally how that looks. So that's how our world has operated, and title companies have operated, and the Wyoming courts have operated, and lawyers have operated forever in Wyoming, is that designation of husband and wife means that you own it entirely, and one of you dies, it goes to the others, with rights of survivorship is another way you might have heard of that. Notably, there's been a series of court cases, both in our state courts and in the federal court, that called this into question of whether or not that created a tenancy by the entirety. And in 2019, there was a Wyoming federal court case that said it did not, and instead was tenants in common. And one of the bases that the court looked at in coming to that determination was our own statute. And so if I can draw your attention to the bill draft, page 1, lines 13 through 15, going on to page 2, lines 1 through 4. This is current statute. This is the law as it currently exists. And it states a joint tenancy or a tenancy by the entirety as to any interest in real or personal property may be established by the owner thereof by designating the instrument of conveyance or transfer, the names of such joint tenants or tenants by the entirety, including his own, without the necessity of any transfer or conveyance to or through a third person. Notably, as you kind of try to digest what that says, I just want to draw your attention to the fact it does not say husband and wife. And so our law is silent as to the significance of the designation husband and wife. This bill closes that loop and fills in that gap by looking at the new language on page 2, lines 6 through 10, that specifically provides that the designation of tenants on an instrument of conveyance or transfer of real property is, quote, husband and wife or spouses, that sometimes might be on your deeds right now. It just says that, or similar language shall be sufficient to establish a tenancy by the entirety. So that's what the bill does. Happy to stand for questions.
Committee, any questions for Senator Nethercott? Representative Jennings.
Thank you, Chairman. Senator, so how does, so the two brothers have that and they're considered half owners. And the couple is always considered, it goes directly to the other. So currently, is there not a method by which one brother wants to give the entire thing, one of them dies and the other? How does that currently occur if they want that to happen?
Senator Nethercott.
Madam Chairman, there's a variety of ways, but for purposes limited to this kind of conversation, it would be in the deed itself. So they would need to deal with that pursuant to the language currently in statute, and they would need to say as tenants by the entirety. What we find in the world is that people like to do this without the assistance of lawyers or title companies. And they do it all the time with quitclaim deeds, and they don't know the significance of providing those designations. And so they'll just say, you know, who the owners of the property are and don't delineate whether or not it is tenancy by the entirety or not. But if the brothers wanted to do that, they could put it by tenancy by the entirety on the deed language, and that would resolve that issue in the same way as husband and wife would resolve that issue.
Follow up?
Thank you, Mr. Chairman. So it looks like to me that this would switch it then, so that the brothers then would then be filed as joint tenancy or the one where it goes directly to the other. And so if we didn't want that to happen, now they're going to have to, does that make sense that there's, okay. So currently, if two brothers owned that, they would be considered typically each owning half. But if we pass this, they would be considered right of owning that if the other one died.
Madam Chairman,
Senator Nethercott.
only if the brothers are married. And I say that jokingly. So no, the brothers would own it as tenants in common, which is that kind of 50-50 concept. Unless the deed said John and Jim Smith as tenants by the entirety, then they would own it. Then the other would inherit it if one died. Because they can't be married, this just resolves the issue as it relates to spouses and the failure or what the meaning is to have husband and wife on a deed. And it allows for that tenancy by the entirety, which is likely what you intended, but may not be what happens if one of you dies right now. It's really important we close this loophole.
Representative Chestick.
Thank you, Madam Chairman. Senator Nethercott. I can foresee unusual circumstance, but a possible circumstance in which spouses intend to own property as tenants in common. It's a possibility. And I also, as you know, I teach legal writing and I teach some transactional drafting. And one of the jobs of the transactional lawyer is to try and figure out what can go wrong. And what can go wrong here is a deed says X and Y, husband and wife as tenants in common. What does that create? It's a little confusing with a new language. So it seems to me what you're trying to do is define when the deed says nothing but husband and wife or spouses, that should create a tenancy by the entireties. So I would just run this past you as a possible amendment to clear that up. on line 8, insert after similar language, comma, without more, comma, shall be deemed to create a tenancy by the entireties. But if you, the hypothetical I gave you where they put as tenants in common, that is the more that would make it a tenancy in common. Would that be a sufficient amendment, do you think, to clear up that possible error?
Senator Nethercott.
Madam Chairman, I do not know.
Why not?
Well,
Follow up?
Sorry. Thank you,
Madam
Madam Chairman. Why not?
Madam Chairman, thank you. I think we need to be prescriptive when it comes to deeds and statute. Without more, I think it's too ambiguous as to what that means. I still think that that would be challenged if someone, if that deed said husband and wife as tenants in common, that creates an absurdity in the law, and an absurdity is a commonly used phrase by the court systems when a legal result is inconsistent. And so that would create an absurd result, right? That there is an inherent conflict in that four corners of that deed, which would result in litigation. And the without more language would not resolve that.
Follow up? Additional questions of Senator Nethercott. Chairman Washit.
Thank you, Madam Co-Chair or Vice Chair. Senator, trying to wrap my non-lawyer brain around all this. It sounds like we probably have thousands of deeds on file around Wyoming that talk about husband and wife or spouses. And the assumption is when I die, my wife gets the place. And now you're saying that a 2019 federal court case has called that assumption into question, and it may not work that way. So we need this language to make sure that all these thousands of deeds work as intended. Is that what we're after here?
Senator Nethercott.
Madam Chairman, I would say tens of thousands of deeds. Yes, Representative Washit.
Follow up? Additional questions? Seeing none. Is there any departments, agencies that would like to testify? Anybody online? Representative Jennings.
Thank you, Chairman. So Senator, so the court basically pointed out this problem. I mean, it took something that had been commonly understood and they turned that basically on its ear. So since they've done that, what has been the result across the state?
Senator Nethercott.
Madam Chairman, I don't think it's been challenged yet in the courts that way. I think that the things are proceeding as has historically been understood, but it is creating a lot of uncertainty with title companies, legal practitioners about the significance of this decision.
Follow up? Okay. Any public testimony on Senate File 91? Seeing none, we'll go ahead and close public testimony. Committee, what is your pleasure? Moved by Representative Provenza, second by Chairman Washit. Any amendments, discussion?
Yes.
Representative Chestick.
Yes, Madam Chairman, I would like to propose an amendment because I do believe that it is a foreseeable problem when somebody creates a deed that says husband and wife has tenants in common, because that is something they could legally do. It's possible to have that arrangement. I think to clear that up, I would like to propose the amendment on line 8. After similar language, comma, insert the words without more, comma, and then replace the word sufficient with deemed. And the rationale for that is I do believe that any deed that says husband and wife or spouse and that's it should create a tenancy by entirety. That's the intent of the bill, I believe. But this is simply an effort to account for that rare but possible situation where husband and wife do in fact want to be held as tenants in common.
Is there a second? seconded by Representative Provenza. Discussion. Representative Provenza.
Thank you, Madam Chair. Can you clarify? So we're saying without more shall be deemed to establish a tenancy. So does that mean this is just the assumption if there isn't any paperwork that says otherwise?
Madam Chairman.
Representative Chestnut.
Madam Chairman, thank you. The only paperwork is the deed, right? What the deed is a legal instrument that has legal effect, and what is the effect of the words in the deed is what we're trying to clarify here. So if the deed says husband and wife or spouse or similar language, and then nothing else, that's going to create a tenancy by the entirety, period. That's the legal effect of how you hold the property. But if they add after spouse or that identical language as tenants in common, then the words as tenants in common will control, because that is the more, that's more than just what the original, it's more than just spouse or anything else. So that gets you after deemer, then you have a tenancy in common, which is what they intended. And they're allowed to do that. There's nothing wrong with spouses holding property as tenants in common. Very rare. But I think there is a possibility that it could happen, or sometimes does happen.
Madam Chairman.
Senator Nethercott.
Thank you. Thank you for permission to intervene on your discussion on an amendment. Perhaps to focus in on this is to provide more prescriptive language that says, unless the deed identifies another type of ownership, instead of without more. Without more requires, doesn't mean anything, because more is husband and wife. And that creates a tenancy by the entirety, which is inconsistent with tenants in common, which is also more. So there's this inclusion of two separate legal results. That's more, right? And so without, that does not resolve the without more. So if you want to address the issue of the nonsensical result of somebody putting husband and wife and tenants in common in the same deed, to state that the tenants in common prevails. Hopefully, that's what the lovely husband and wife intended without knowing what tenants in common meant.
Additional comments on the amendment?
Madam Chairman.
Representative Chester.
I would actually, I think that's a better solution. And if I may, I can withdraw my first amendment and propose a different amendment.
The amendment's been withdrawn.
Okay, Madam Chairman, the second amendment.
Representative Chester.
The second amendment, the replacement amendment would be on line 10. Replace the period with a comma, and then add the words unless the deed specifies another form of ownership.
Does our clerk have that amendment? All right, is there a second? Representative, seconded by Representative Provenza. Discussion on the amendment. Representative Jennings.
Chairman, it seems to me like that's the common practice now, that it would defer to that or default to that if someone put that in there on their deed anyway. So this one's addressing the entirety aspect, it seems like to me. And so it seems like that's trying to pull in the tenancy in common. And so it seems to me like that this bill is probably already addressing.
Chairman Washit.
Thank you, Madam Vice Chair. It seems to me that maybe we picked the wrong line to insert that language. I think I would have put the language on line 6 at the introduction here and say, unless otherwise designated on the deed, the designation of tenant on an instrument of conveyance. I think adding it at the end is even more convoluted.
Further discussion on the amendment? Representative Provenza.
Thank you, Madam Vice Chair. I think given the back and forth and trying to figure out where to put it, I think it would be best to come at this potentially at second reading, have further discussion with the bringer of the bill and discuss what would make the most sense, I think, based on her knowledge of the case that came before us.
Any further discussion on the motion, second amendment?
Madam Chairman. If I may. Representative Chestick, I think you should say that's a friendly amendment and go with Representative Washington.
Representative Chesty.
Or I can go with the suggestion of doing it as a committee of the whole amendment. I do agree that Chairman Washitt's amendment makes sense. I also think I would change the word sufficient to deemed, but we're getting kind of bogged down here, so. Shall be sufficient is a little fuzzy, shall be deemed is what, and I think Senator Nethercott, deemed is what you're trying to get at, I believe. Is that correct?
So we still have a motion on the amendment.
I'm just trying to get some more information from Senator Nethercott about changing the word sufficient to deemed.
We will go ahead and vote.
Well, no, all right. In that case, I'll withdraw the amendment and I'll talk with Senator Nethercott after the meeting.
Okay, Representative Chestick has withdrawn his amendment. Question being called on the bill. Go ahead and roll call vote.
Representative Craigo,
We have a absentee vote of aye.
Representative Chestick,
Aye.
Representative Haroldson, Representative Jennings, Representative Nemec, Representative Oakley,
Aye.
Representative Provenza,
Aye.
Chairman Washitt,
Aye.
Vice Chairman Rodriguez Williams.
Aye.
We have a total of 9 ayes and 0 noes.
Okay, with that being said, Senate File 91 is passed. Thank you to Senator Nethercott for being with us. We will move on to Senate File 56. You want to go ahead? Huh? Okay, we're moving on to Senate File 56, prohibiting travel across private land for hunting purposes. And we have Representative Craigo introducing the bill. Go ahead and explain the bill to us.
Thank you, Madam Chairman. Barry Craigo, House District 40. Committee members, I bring to you Senate File 56 this morning, prohibiting travel across private land for hunting purposes. This is a bill we worked over the interim through Judiciary. It sort of started with somebody's personal bill last year during session, and it morphed into this. And really what this is, and I'll walk through the language in a minute, but really what the purpose of the bill is to allow our game wardens who are in the field to actually write trespass tickets. Because as the statute's written right now, our local game and fish wardens can only write a ticket if they actually find somebody in the process of hunting on private property. And so the act of driving through someone's fee simple private property to get to public property for the purpose of hunting is not covered under the statute as written. So what we're trying to do with this particular bill is to say, if you drive through someone's private property to go hunt on public property or return there from after hunting, that is considered a trespass under the law. And the reason we're trying to do this is there is a criminal trespass statute that deals with that. But our game wardens who are in the field during hunting season can't deal with that problem. They can't write that ticket. And the best they can do is call the local sheriff or deputy sheriff, who's typically not out in the field during hunting season. They may make rounds, but that's just not in their job duty as much as it is the game wardens. And so we're trying to give them an extra tool in their toolbox to deal with this problem. think everybody, right now trespass is a big issue. Access is a big issue. And so we're just trying to set us all up for success moving forward, whether it's the hunters, the anglers, landowners. We just need to get some better rules in place to help us as we move forward. We just need to make sure what the rules are and that they're enforceable. And so that's really what this was an attempt to do, is say, hey, if you're out in the field and you're driving through somebody's property, but you're not hunting, it's still trespass. And the game warden who sees you do it can actually write the ticket rather than having to call the local deputy to come, oftentimes from 2 or 3 hours away one way, right? I mean, these are things that happen in the backcountry, and the game wardens are the only ones even remotely close. And so on page 1 at the bottom, part B, we added the language travel through or return across, and then the word take wildlife there at the very bottom. And then, and this might be, what I would say is maybe one of the most important parts of the bill draft is on line 5, it says, for purposes of this subsection, travel through or return across requires physically touching or driving on the surface of the private property. The point of that language is to make sure that we're not making a statement one way or the other on corner crossing. We're not trying to address corner crossing. We're not making it legal. We're not making it illegal. We're saying we're not getting in the middle of this. We're really talking about the people who blatantly drive across or walk across somebody's private property to go hunt, knowing that as long as they aren't hunting on the property, right, as the law is written right now, they can't get a ticket except from somebody from the sheriff's office. And so that's what that part of the language, we had a lot of concerns that this had to do with corner crossing. And so that's what that language was added for, was to ensure that we're not talking about that. And so I think we had lots of good testimony, lots of good support through the interim from hunters, from anglers, from landowners. Everybody thought this was a good bill because 99% of our hunters don't want to trespass, and they want to make sure they're not doing something wrong. And this allows us to get the other 1% that is ignoring the law and going wherever they want. So anyways, with that, I'd stand for any questions. And I know there's a lot of people here to testify on this, so I'll try to keep it as short as possible.
Thank you, Representative Craigo. Any questions from the committee for Representative Craigo? Seeing none, we'll go ahead and open it up to agencies, departments that wish to testify on behalf of the bill. Please go ahead and come forward, Mr. King.
Good morning, Madam Chair, members of the committee. My name is Rick King. I'm Chief Game Warden with the Wyoming Game and Fish Department. I'll make my comments pretty brief as well. I've had the opportunity to discuss this bill during the interim. At the November meeting, it was suggested that we bring forth some examples of where this may come into play. So I'll just quickly highlight those. I'll just make them hypothetical examples, but they're real world and applicable. So for example, if you have a hunter that's say spots some elk across a canyon, and it's in an area where there's mixed land ownership, public and private land. And in order to get to those elk, they drive, walk, or snow machine or ATV across deeded ground and end up getting to those elk. They may imagine most folks have a GPS or Onyx on their phone, so they disregard the info from their Onyx or GPS and just take the quickest path to get to those elk and then harvest elk. There have been some courts that have found that if that harvest didn't occur on deeded public land or on deeded land, that it may not be considered a trespass, even though that act prior to getting over there was just blatant disregard of private property rights. That's one real world example. A second may be that a person utilizing Onyx or their GPS unit legally stays on public land, harvests an animal, everything's legal up to that point. But they decide that rather than taking that long route back to their vehicle and stay on public land, they decide to take a shortcut back across private land to shorten the effort. Those are two real world examples where I see this helps provide some clarification that no, that activity is actually part and parcel to the hunt, and common sense would just say that this should be included within the Title 23 trespass. So with that, I'll stop there and stand for any questions that you might have.
Thank you, Mr. King. Any questions? Chairman Washington.
Thank you, Madam Vice Chair. Just a quick education for those members that were not on the committee during the interim. The difference between hunting trespass and criminal trespass. Could you highlight some of the distinctions?
Mr. King.
Madam Chair, Chairman Washit. So criminal trespass under Title VI requires a person has to be notified that they're trespassing. And then after notification, then they can be cited for trespassing. Under Title 23, it's more of a strict liability in that the sports person needs to know whether they're on private or public land. If they're on private land, they have to have express permission to be there. Those are the two primary differences. And as it was mentioned, Game and Fish Officers Limited Peace Officer Authority does not allow for game wardens to enforce criminal trespass, only trespass under Title 23.
Additional questions from the committee? Representative Provenza.
Thank you, Madam Vice Chair. Mr. King, I'm just kind of rereading this with fresh eyes after the interim. And so no person shall enter upon, and with the current language, no person shall enter upon the private property of any person. Why does that not cover moving across someone's land? I mean, that you have entered, correct? So can you kind of maybe make that clear for me? Maybe I'm dense or it's too early. I don't know what my problem is, but I'm trying to clarify that.
Mr. King.
Madam Chair, Representative Provenza, that what you highlighted would be, more the common sense interpretation is that this should already be covered. But there have been some courts that have found that if a person didn't actually harvest an animal on private land, that even though they trespassed in order to participate in that hunt, that it may not be considered trespass under Game and Fish statute. So this provides that clarification where those instances where the successful harvest wouldn't have occurred without that travel through or return across private land.
Follow up, Representative Provenza.
Thank you, Madam Vice Chair. So, and there's no intent in this. So if we inserted intent that the person was intending to enter upon to hunt fish, would that accomplish the same thing?
Mr. King.
Madam Chair, Representative Provenza, where would you insert intent?
Representative Provenza.
Thanks. I mean, so in our Game and Fish statutes, unlike our criminal statutes, there's sometimes there's not a knowingly or an intent to, correct? And so if intent were part of this no trespass for hunting, I mean, that gets into the issue of Title VI versus Title 23. But then that brings in that state of mind of you were intending to hunt fish and you entered upon private land to do so. So I don't know exactly where I put it. So maybe no person shall knowingly enter upon.
Mr. King.
Madam Chair, Representative Provenza, as I mentioned in Game and Fish Title 23 trespass, there currently isn't knowingly or intent provided. It's strict liability, and that sports person are supposed to know whether or not they're on deeded land or public land and whether or not they have express permission or not. So I think that I guess I don't have an answer for you. I think the intent and knowingly is a bigger discussion outside of this bill probably would be my recommendation.
Additional questions?
Yeah.
Representative Jennings.
Madam Chairman, Mr. King, Currently, does the Fish and Game warden have the right to detain that person that's going across private land and until a sheriff's officer arrived?
Mr. King.
Madam Chair, Representative Jennings, on a case-by-case basis. So for example, hypothetically, if our wardens observed somebody on deeded public land and they contacted them and asked if they had permission, and if at that point the person couldn't prove that they had permission to be there, that would establish some reasonable suspicion for them to continue to investigate further, which may mean a phone call to a landowner. And from there, it could potentially result in our game and fish officer staying there until a sheriff arrives if it is determined that that's more of a criminal trespass case. But it would all be case by case and requires the warden to, establish reasonable suspicion of a violation.
Follow up.
Thank you, Madam Chairman. So he does have the right to detain them, and if he suspects a criminal trespass, he could detain them until a sheriff deputy arrived.
Mr. King.
Madam Chair, Representative Jennings, I think, again, with every case is unique. And so I think that if a warden established some reasonable suspicion that there was a violation and in contact with a landowner, a lot of this is dependent upon a landowner and their desire to have somebody trespassed or not. And so I think in a case where a game warden determined that a person was on deeded land, they didn't have permission to be there. If there was a question about the activity, whether it was related to hunting or not, and it fell under criminal trespass, we would most likely contact the sheriff's office. And if the sheriff wanted us to remain there until somebody could arrive to deal with it, we could. But in a lot of cases, we could just take the information and turn that over to the sheriff's office, and the sheriff's office could deal with it later. So I'm not trying to avoid your question. I just think that every scenario is pretty different, and detaining somebody there is going to be case by case specific and really fall back to the circumstances at hand.
Chairman Washit.
Thank you, Madam Vice Chair. Mr. King, as the boss of the wardens, do you think it's a good use of your warden's time to sit with an offender for 2 or 3 hours while you wait for a deputy sheriff to respond?
Mr. King.
Madam Chair, Chairman Washit, our folks are pretty busy. They have a lot going on. We deal with a lot of trespass cases. And I think that while certainly if it helps the sheriff's office to do something like that, we'd certainly do it. But in an ideal situation, no, we got a lot of stuff going on during a day, and staying there for several hours to deal with a minor trespass violation is probably not a great use of our time.
Additional questions from the committee? Seeing none, Mr. King, thank you for your testimony. Further testimony from agencies, departments? Okay, we'll go ahead and open it up for public comment. Anybody would like to come forward?
Thank you, Madam Vice Chair. Jim McGagnon with the Wyoming Stock Growers Association, and also representing the Wyoming Wool Growers Association today. And we've been very supportive of this legislation for the reasons that's already been explained, to have some consistency between this and Title VI criminal trespass. But it might be helpful to give you an example that I've heard from more than once from a member of ours, where they will find someone trespassing across their private land, approach them, and they have wildlife in the back of their vehicle. They've harvested an animal, and they're asked the question and they maybe don't say where they harvested, or they say, oh, I did it on public land. If the landowner contacts the game warden, and they typically have good relationships with game wardens, particularly during the hunting season, and says, I found this individual on my land with an elk in the back of his pickup and asking for your assistance. A question the game warden will often ask, not always, but often ask is, was that animal harvested on your land? The landowner doesn't have the answer to that. So as a result, the Game and Fish, being otherwise busy, will be reluctant to come out there, because not knowing that, they're not in a position to issue a citation. I think this provides that clarity that if you're on the land and you're hunting, even if you've got the animal in the back of your pickup, where did you harvest that animal becomes immaterial. You harvested an animal, you're trespassing on private land while in the possession of that animal, or while seeking an animal to take in a hunting expedition. So we think this just makes the current law work better, respect the private property rights of landowners, and removes the confusion about something that can often not be clearly determined as to where the animal was harvested, and would urge your support of the bill as it is written. I'd be happy to entertain any questions.
Thank you, Mr. McGagnon. Any questions from the committee? Seeing none, thank you. Further testimony.
Madam Chairwoman, members of the committee, Sabrina King with the Wyoming chapter of Backcountry Hunters and Anglers. And we do support the bill, and I just wanted to provide a little bit of additional context. We've talked a lot about, and I think especially in trespass conversations, we speak a great deal about hunting trespass, but this statute also deals with angling and trapping. One of our original concerns with the bill last year was that without that definition of travel through, for anglers who have the right to float, over private property, there were some questions about, without this definition, would this impact an angler's ability to access that water? And so I think the committee did good work over the interim, frankly, I think, in finding the right definition and providing some clarity for that. So from our perspective, I think for our hunters and anglers, we've really taken the approach to the myriad of trespass legislation in the session to say, what we really need is clarity for hunters and anglers. We need clarity in the law. We need everyone to have the same understanding about what is legal and what is not. And for us to be able to work with our membership to ensure that we are following the letter of the law, we need that law to be clear. So we appreciate the bill. We support it. Hope it passes through, and happy to answer any questions.
Thank you, Ms. King. Any questions from the committee? Seeing none. Further testimony. Good morning. Please state your name.
Madam Vice Chair, Chairman, members of the committee, Jess Johnson. I'm with the Wyoming Wildlife Federation, and I won't belabor the point. We stand in support of this bill exactly as the BHA representative said as well, and just see it as clarification. We don't see it as over prescriptive. We say it as being able to limit the bad players on the landscape while the good players can still go out and enjoy hunting and fishing as we have it. So thank you for this, and we hope this bill passes.
Thank you. Any questions for Ms. Johnson? Seeing none. Further testimony?
Thank you, Madam Chairman. Brett Moline, Wyoming Farm Bureau Federation, sitting in support of this bill for all the reasons that have already been outlined. I think the two things this bill really does is it protects private property. And I also think that by limiting the nefarious people out there, it also helps protect the resources that we're also proud and happy to have in our state. So sitting in support of this bill, I would sit for any questions you or the committee may have for me.
Thank you, Mr. Moline. Any questions from the committee? Thanks for being here.
Thank you.
Further testimony. Mr. Odokoven.
Thank you, Madam Chair. Byron Odokoven, the Executive Director for the Wyoming Association of Sheriffs and Chiefs of Police, rising in support of the bill. And let me reiterate two of the points that were made earlier and offer that I think this is a good use of time to balance that time between the game and fish officer who's on scene and present versus that calling of a deputy resource and tying up that time of both while we deal with one singular incident. Second, I think this also is in line, as was commented, with the game and fish portion of the trespass. And that is on the game and fish trespass, you're presumed to know where you are. This continues that and clarifies that you know where you are when you're taking wildlife hunting, fishing, et cetera. So I think that's consistent. So I think that's good in terms of our public policy, to have public policy that is consistent. Third, in terms of receiving those calls and dealing with those issues, I think it's important to have those first people on the scene be able to deal with it quickly. The question was, can you hold a person on scene pending a deputy coming? If you hearken back to a discussion of a traffic stop, for example, how long can we keep a person on a traffic stop? And the court has started to narrow that time window significantly from bygone days of you can keep them there for quite a while other additional resources arrive, to a much shorter period of time. So I liken that to this discussion would offer a degree of caution that we should deal with the circumstance. We should deal with it promptly and get folks back to traveling on their way as soon as possible. Madam Chair.
Committee questions? Chairman Washit.
Thank you, Madam Vice Chair. So as I read this bill, it seems that there's only one circumstance where this is, maybe more one, but it seems one circumstance where this would be different than Title VI criminal trespass. That in Mr. McGagn's testimony, the individual who drives past your gate with a no trespassing sign and he's got an elk in the back of his truck, that's criminal trespass presently. However, if someone climbs over the fence, not near a sign or posting, and is walking across the deeded land on their way to public land on the other side of the deeded land, with intent to hunt on that public land on the other side, that would then be a violation of this, but would not be a Title VI violation until they'd been told or asked to leave, correct?
Mr. Odekoven.
Thank you, Madam Chair. That is correct. That's some of the ambiguity that we've wrestled with in the criminal trespass world for several legislative sessions, trying to sort that. Do you have to be warned first? So your first trespass is your Ollie Alex and free. You don't have a trespass on your first trespass. You have a trespass on your second trespass, provided you're trespassing in the first place that you trespassed. If you're trespassing in a new place that you've trespassed for the first time, you're probably going to get a second pass a second time. And on the story goes, unfortunately. So I think creates that distinction, if you will, that we'll deal with this matter of hunting now, and we'll deal with other forms of trespass in a different manner. Madam Chair.
Additional questions? Okay, seeing none, thank you, Mr. Odekoven.
Thank you.
Additional public testimony. Please come forward. Welcome. Go ahead and state your name.
President of the Wyoming Sportsman Association.
Sir, you'll need to go ahead and press the green button right there on the microphone. And if you can go ahead and repeat your name for the record. Thank you.
Committee, my name is John Bird. I was past president of the Wyoming Sportsman Association for years. And now I'm just here to represent a bunch of sportsmen around the state, hundreds of them that have called me and asked me to be here, specifically on this bill. I'd like to say, first of all, that hunting and trapping have been traditional in Wyoming long before it was a state or territory, and long before ranchers and outfitters existed. I'm down here, I'd like to take the position that the current statute, Wyoming Statute 23.3 305B, is sufficient for the following reasons. The Game and Fish stated in their testimony for the Senate Travel Recreation Committee and this committee that there had been problems with the current statute and interpretation and enforcement. In 2004, I gave you guys a copy of the Attorney General position. The Attorney General was asked to make an opinion on corner crossing. And before he could make that opinion on corner crossing, he had to go through and sort out exactly what it took to convict under that statute. In his answer on paragraph page page 4, at the very end, after taking a look at the statute and dissecting it, as the Attorney General would, he came out accordingly. In order to be found guilty of Wyoming statute 233305B, one has to, without permission, enter the upon private property of another with the intent to hunt, fish, or trap on that private property. That was in 2004. And 19 years later, and I'm not an attorney, so I'm going on what judges have told me and other attorneys have told me. An attorney general position that hasn't been corrected by a court or hasn't been corrected by a legislature becomes the standard by which to prosecute. So that was in 2004. For the last 19 years, the Game and Fish haven't used this attorney general position. In fact, they've kind of ignored it. They've addressed it to corner crossing only. But this position goes back to what it takes to convict on the statute itself. And it's very explicit on it. The Game and Fish for this statute, or when this attorney general position was released, should have used it in their prosecutions. They should have got it out and trained their law enforcement agents, you know, that it required intent. That's where the misinterpretation has come. It hasn't been addressed. It hasn't been addressed by the Game and Fish. Many courts in the state do not know about it. They've heard about it for corner crossing, but they've never sat down to read it in conjunction with the statute as it sets itself. And I'd state that the vast best representation is by the lack of proper training by game wardens, and, you know, taking into account the 2004 AG opinion, and it left it open for the last 19 years for local game wardens to interpret to themselves. Most people, when charged with this statute, would rather pay the $450 fine than hire an attorney for between $5,000 and $10,000 to fight it. Over the last 19 years, there have been a lot of people charged wrongfully under the statute, and either the wrongfully were charged by the state, either by the intentional disregard of the AG opinion, by the Game and Fish leadership itself, including the commission. I'd like to talk some about the background before we go on. Criminal trespass requires notification. It says Wyoming statute 63303 states a person is guilty of criminal trespass if he enters or remains on or in the land or premises of another person, knowing he is not authorized to do so, or after being notified to depart or not to trespass. For purposes of this section, notice is given by personal communication to the person by the owner or occupant or his agent, or by a peace officer, or by posting of signs reasonably likely to come to the attention of intruders. In 2020, there was an attempt via Senate File 67 to remove the notification requirements, and it failed miserably, and rightfully so. Just one example, over the years, there have been many attempts by mainly outfitters and rancher outfitters to block off access or to just harass hunters themselves with self-serving statutes. This is another one of those issues. Many proponents of the Senate File 56 state that the sportsman should know where he is at all times. And with the advent of GPS, he really doesn't have an excuse. Nowhere in any statute or any rule does it state that a sportsman must carry a GPS or even use a GPS or map for hunting, nor should it be. In talking with Onyx, they state that their mapping is not the end all say all and is meant only to be used as a tool. Many people have taken a look at Onyx, and there are discrepancies between Onyx. Representative Craigo last week in his discussion with Bill said there was problems on his property. There's been problems with GPS in a lot of areas, the National Health Refuge, the national parks, because the lines don't necessarily fall. The GPS uses the map overlay, and a map overlay is based on a Lambert formal, which takes two lines of position to overlay that over for a map. Roads and trails were added off 60s and 50s maps to give those roads and trails. And property lines don't necessarily reflect property lines. Many ranches around the state, fences are not on property lines. They are basically on pastures. That's where they have been traditionally. Very few of them actually set on a property line itself. I know of many instances around the state where there's a fence that says no trespassing, but if you look on Onyx, it shows the boundary line being 200 or 300 yards this side of it, the side that you're walking. And a lot of landowners have allowed that over the years. And now let me speak a little bit about the ramifications of Senate File 56. If you have questions on GPS, you can go ahead and ask me. I was a navigator for 22 years in the Air Force. I fully understand GPS. Yeah. First of all, this bill is targeted discrimination against hunters, fishermen, trappers, and shed hunters. It does not address things like rock hounding, arrowhead hunters, prospecting, or just exploring historical trails. It may even violate the Equal Protections Clause of the 14th Amendment because of this. The bill seeks to task an independent organization, the Game and Fish, with providing policing responsibility without considering the fiscal implications for enforcement, nor does it provide funds for that enforcement. This bill would take game wardens off their primary responsibility of protecting and managing wildlife. It would make game warden a de facto private security guard for private interests, landowners, and outfitters. The idea that game warden is more accessible than a sheriff is wrong. It may take a sheriff a couple hours to respond, but the same applies to game wardens that may not be in the area at that time, plus the fact that there's vastly less game wardens than sheriff's deputies. The bill lends itself to numerous prosecutions by overzealous game wardens. Gone are the days of the friendly interaction with local game wardens. And I'm a 70-year resident. I'm a 5th generation resident. And over my life, the discussions with game wardens were always very friendly. Now it's become more of an inquisition when you see one. Where are you? How'd you get here? When did you come here? Did you trespass to get here? The whole line of inquisitions to make game wardens, people don't want to deal with them anymore. The bill could lead to prosecutions for something as innocent as driving onto a property to ask for permission, something all sportsmen have been trained to do for years since youth, or to notify the landowner of a problem on his property, sick livestock, fence down. It doesn't separate when you're hunting, whether you were asking for permission, whether you were innocently trying to help the landowner or not. You are guilty of the trespass. The bill would cause all property to be off limits, even if historically a landowner would allow access to his property to public lands. And there are many, 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 many landowners in Wyoming that do that. There are still many ranches in Wyoming that have the signs on gates stating public and private lands beyond this sign, no hunting on private lands. Many instances of that. Throughout the millions of acres of public land, on the back page of that, you'll find a picture. And that picture shows Onyx maps of one small area in the rattlesnakes in Wyoming. And that 22 sections of land, there are 10 40-acre sections, 40-acre parcels, which are very small. That's 1/8 of a mile by 1/8 of a mile, 200 yards by 200 yards. That sit within those parcels. Across about every one of those 40-acre parcels are roads and trails that access the public lands. Many landowners I've talked to over the years about this issue, they don't know where those 40 acres are. They have an idea. They can't tell you exactly, and nor do they care. One instance is the Dumbbell Ranch. We had Bruce Cupperson run it. I asked Bruce, he said, so what are you going to do with all these 40s? And Bruce says, I don't care about those 40s. And many landowners don't, unless they're trying to block access to the public lands. And this bill may have the impact of blocking millions upon millions of acres of public lands from hunters and fishermen, which I'm a firm believer in public and private property rights. I own a lot of property. But I'm also a firm believer in providing access for our kids and our grandkids and the hunting people that are coming up in this sport. Right now, we have a problem bringing kids and women into the sport, and we further limit access. You know, and there's a lot of problems with limiting this access and what is the impact it's going to be on the game and fish itself, managing wildlife, and on managing the hunters. My preference would be for the legislature to defeat this bill in its entirety and rely on the original statute, taking into account the Attorney General position. It fully covers everything the statute has. Barring that, if that can't be done, I think a simple one-word amendment would make this bill acceptable to sportsmen across the state. Change Senate File 56 to be close to the criminal trespass file, and where it says no person shall enter upon, travel through, or return across, add the posted property of any person to take wildlife. And the reason I ask you to do this is when you've got a GPS, and I've been hunting a lot and I hunt with a lot of people, it's awful hard to keep an eye on that GPS. Most people keep it in their pocket, pull it out to look at it, where they're going. If they're driving, then they really have a hard time trying to maintain. It's very easy to run into and make a small incursion onto private property. I understand that. But if they post the area, post the property, even the little 40s, then you've given the hunters notification. You've given them a visual reference that they are trespassing, and they can make sure they don't. You're always going to have the ones that are going to do it anyway. And if they do it, then you still have them because they have intent. So,
Mr. Byrd, let's go ahead and wrap it up so we can address questions.
that's all I have. I'm open to any questions.
Thank you, Mr. Byrd.
Sure.
Committee, any questions of Mr. Byrd? Representative Jennings.
Thank you, Chairman. Mr. Byrd, so since you brought it up, it might be a question for Mr. Odokoven or Mr. King, but since you brought it up, so fence line's not on the actual property according to the Onyx system that you're talking about. How does that work? I mean, does the Fish and Game then, do they pull out their GPS and figure that out? I mean, because the guy's on one side of the fence or the other, and he's not really on private property, or he really is on private property. How did that function? He
Mr.
doesn't
Byrd.
see,
Mr.
the
Byrd.
private property.
Mr. Byrd,
Oh, excuse me, Madam Chairman.
please address the chairman. Thank you.
Madam
ahead.
Chairman, let's talk about an instance in the Diamond Ring Ranch in central Wyoming, one that I know very well. They post most all their land. Those signs are posted on fences, that they are worried about you trespassing on. However, there's two instances that are funny with the Diamond Ring Ranch. There's one access to a mountain, but the fence sets 100 yards to the west of where the actual property line is. The ranch has never cared if you use that land. It's mainly it's on a thoroughfare to get to the top of the mountain. There's other instances of property that are outside their fences from Snyder Basin they don't care about. However, there are some areas they care about, or I shouldn't say they care about necessarily. The Game and Fish is cared about because we have one game warden, Casper, that is so overzealous, he will charge you with trespass for one area, but not the other. And you don't know at that time without signage whether you are allowed to be there or not to be there. The dumbbell historically has always allowed access to their property. However, when the Pathfinder and the dumbbell and the bugs were sold to a California operation, they hired outfitters to manage their hunting. So consequently, now they're trying to charge you to hunt or to access public lands. And there's been even instances of people paying to hunt public lands, not knowing that they could hunt it without paying a trespass fee. It
Thank
makes
you,
it,
Mr. Byrd. Any follow-up?
yeah, Mr. Chairman. So the real question was, What does law enforcement do? I mean, so that guy's 100 yards on the other side of the fence, but he's technically still on public land. How does law enforcement? Do they use the same GPS system that? I mean, because
Mr.
Madam,
Byrd.
sorry. Madam Chairman, yeah, absolutely. They use the GPS. They depend on it as if it's the end all say all, and it isn't.
Additional questions for Mr. Byrd? Representative Provenza.
Thank you, Madam Vice Chair. Mr. Byrd, do you know how much, what are the implications of this, I guess, in terms of access then? Do you know how many acres would potentially be shut off? Or I'm just trying to understand what happens if we pass this.
In this little
Mr.
area,
Byrd.
sorry, Madam Chairman. In this little area I showed you the map of, there's about 25, 26 sections. There's 10 sections, 10 little parcels, 40-acre parcels. Of those 40-acre parcels, every one of them sets on a road. You can't get around them because the BLM has rules that allow you off the road, existing roads so far. And so basically, it's one of those, you can, you can't. If it blocks off that road by a little parcel of private, it blocks off the road, period, because you can't get off that road without violating BLM rules. And you can't make a new road. And so what it does is it has the effect to shut off thousands upon thousands upon thousands of acres of public land. And when you shut off that public land, you drive public land hunters onto the other parcels. And then you have overhunting. You have the hunters aren't having a good experience because there are so many crammed in a local area. You overhunt the wildlife, causing problems for the game and fish and in wildlife management and protection, especially their wildlife management. All the animals are on sections of public land that you can't.
Thank you. Additional. Representative Craigo.
Thank you, Madam Chairman. So Mr. Byrd, are you suggesting that we allow hunters to drive across private property anytime they want for hunting purposes? Is that what you're telling us today?
Mr. Byrd.
No, I'm telling you to post it, to add a posted sign to it, you know, or have a way of notification to the hunters, because many hunters out there don't have GPSs. They, and a lot of people my age, they don't want to have them. They don't want to learn them. I learned them in the military, so I very much understand them. The private property is private property. If you cross that and there's a posted sign and you're warned, that's criminal trespass anyway.
Follow up. Representative Craigo.
Thank you, Madam Chairman. So do you understand that the purpose of this bill is actually so the game wardens can write a ticket when it is posted property? Because right now they cannot. We have to wait for a sheriff's deputy to get to the field to write the ticket. And they are not allowed to write tickets under Title VI, only under Title 23. Do you understand that?
Mr. Byrd.
What I understand is this is making the game and fish a de facto security guard for private landowners that neither want to post their lands nor want to deal with it.
Additional questions from the committee? Okay, thank you, Mr. Byrd, for being here. Any additional public testimony, please come forward. You both can come up if you'd like. Welcome. You'd please state your name for the record.
My name is Anita Kleiner. I'm an outdoorsman and I'm also a sportsman. I'm from Casper. I'm an outdoorsman all my life. I recently got into hunting about 2007. I've been taught all of my life, you always ask permission before you get on private property. Reading this law, the way it's going to be amended, to me, it tells me if I even approach to ask permission, if there's game warden there, I'm going to get a ticket. And I've been approached by the Game and Fish. How did you get here? You don't have permission. I got permission from that private property owner over the phone. Well, that's not permission. You have to, there's nowhere in the regulations that says I have to have written permission. Just says I have to have permission. I've been approached after I've harvested my animal and I saw a problem with livestock and I was going to tell the property owner that there was a problem. And they told me I was trespassing. I don't see how a game warden should be acting as a private property owner's agent telling me I'm trespassing when I'm approaching a property owner to tell them a problem or asking for permission. I have children that I'm bringing into the sport, and this is not how I feel that they should be brought into it, trying to figure this out. I do use Onyx Sports or Onyx Maps on my phone, and it kills my phone within 4 hours. And that's the only app open on my phone. I have noticed that it does jump. It shows that a road will be on public. I'll be on that road, and all of a sudden, I'm on private. I do not understand. But of course, that tells me it's not completely accurate. The Wyoming Game and Fish tells me the game Onyx is the be-all, end-all. The federal wildlife on the elk refuge says it is totally inaccurate. I don't see how we can go through with this law unless we put amendments for it to be posted, because then that makes the Game and Fish not acting as an agent because it is posted. They are acting as a law enforcement for something that is actually posted. If it's not posted, that's acting as a landowner agent, which is kind of like a cop acting as a homeowner agent in town. And the Game and Fish is not going after me when I'm out there looking for arrowheads or when I'm walking the trails. But I have to wear orange during hunting season because I don't want the hunters to get me. But if I've got orange on me when I'm arrowhead hunting, they are going after me. I don't think that's fair either. They're attacking me as a female because I'm in the sport for one already. And now they're going to attack me because I'm a sportsman. That's not fair. Thank you.
Thank you, Ms. Klein. Committee, any questions? Representative Oakley.
Thank you, Madam Chair. So this is a very limited bill. Can you show me in the bill where it would criminalize you for going up to a landowner to tell them about a problem?
Ms. Klein.
It says that if you are on private property, if you cross private property, which if you're going to the property owner's door, you're on private property.
Follow-up, Representative Craigo. Oh, sorry.
Thank you, Madam Chair.
Representative Oakley.
So actually, that isn't at all what the bill says. It's a statute that already exists. And this specifically says travel through to take wildlife, which is a defined, and to hunt, fish, collect. In no way would this criminalize you for going onto private land to get permission from the landowner. I just feel like we're really getting far afield of what the bill does here. So I just want to say that that's not accurate, that that's what this bill would do.
Ms. Klein.
Thank you, Madam Chairman. I've already had a game warden in our local region there in Casper that has already approached me telling me I am trespassing for going up to a private property to talk to a landowner. That's why I'm taking this wording as to tell me that.
Additional questions from the committee? Okay, thank you, Ms. Klein, for being here. Go ahead, sir.
Thank
State
you.
your name.
Madam Vice Chair, members of the committee, Josh Metten with the Theodore Roosevelt Conservation Partnership. We've heard a lot of great testimony today. Obviously, trespass remains a very complex issue. I want to thank the bringer of the bill for the efforts that have gone into this bill. I think we are in support of it. We also share a lot of the concerns, and I appreciate the previous testimony bringing up some of the concerns. I'd say we'd be supportive of including a posting amendment to the bill if that was the interest of the committee. I think, and I'd like to also echo the comments of in support from the other hunting organizations as well. One thing I did want to point out is that this bill seeks to hold bad actors accountable. What it doesn't do is deal with the elephant in the room, which is that we have 4 million acres of landlocked public land in Wyoming. And one thing that would dramatically improve and reduce the amount of trespassing that goes on is if we can tackle that issue and find ways to improve access to legal access to public land while respecting private property rights. One thing the TRCP did on a national level last year is pass the MAP Land Act, which directs federal land agencies to digitize and make publicly available access easements onto public land. We're looking forward to seeing how that helps improve access to public land. We'd like to see that happen. Things like that happen here in the state of Wyoming as well. And so with that, I'd just like to I look forward to working with the members of this body to improve access to public lands and shift this conversation away from the trespass vortex and more towards the access, and which is our birthright as Americans, to public lands. I'll stand for questions.
Committee, any questions for Ms. Minton? Mr. Minton? Representative Provenza.
Thank you, Madam Vice Chair. I'm envisioning times I've been on or thought maybe I was on a public road and it's private road. Specifically, I think this summer I used not Douglas Creek. I used Google to get me to Douglas Creek because I didn't have time to pull my my map out to figure out how to get there. I knew it was convoluted, and Google Maps takes you through then what I find out is a private road. Because in that instance, it was posted. But my concern without the postage is do you have any idea of how many of these roads? Because I agree, we shouldn't have people traveling through people's private land, carrying, an elk on their back or whatever. But in the instance of roads where we think roads are public, if they're private and not posted, do you know how often what's the occurrence of that? I mean, how is that just this one instance where I'm trying to get to Douglas Creek, or do we have lots of private roads that could be confused as public roads to access points?
Mr. Minton.
Madam Vice Chair, Representative Provenza, thank you for that question. I can't say exactly how often that's occurring. I can say from personal experience using mapping software to try and find access to public lands that there's a lot of confusion. And one thing I remember from last week when we were testifying in the Senate TRW about a different trespass bill, there was someone that an expert in GIS that came in and was talking about how inadequate the GIS systems are, and how there's a lot of confusion with that. And so I think that is something that comes into play with this bill and with other trespass issues, is that we need to actively move forward with improving the technology, improving the data, so that we have clarity between the public and whether it's the public or the private interest. We want to have that clarity so people know where they can access and where they can't, whether it's a road or private land.
Additional questions? Okay. Seeing none, thank you, Mr. Minton.
Thank you.
Any additional public comment? Okay, we have one on Zoom. Go ahead and bring Mr. Tanner in.
Yes, good morning, Chairwoman Rodriguez Williams, and I would just like to echo some of the concerns that we've been hearing about this, and that this bill seems to single out sportsmen and not other people who may be wanting to access public land but have to cross privately held land before that. I'd also like to note that securing permission in Wyoming has become a lot more complicated than it used to be, and that the mapping in the county recorder's office is not the same as the GPS maps that we have on our phones. I'd like to note that merely crossing public land or private land that's not marked is not fair if you're going to make this a strict liability offense. I hope that you work to create a notice requirement on this if you're going to impose strict liability penalties on people. And I'd also like to note that while exclusion is a part of the bundle of sticks that we consider to be private property, that doesn't mean that it should be abused to keep the public from accessing their lands. There are plenty of landlocked parcels that we have in the state of Wyoming that sportsmen and women want to be able to access. And not accounting for those interests and only accounting for the interests of private landowners seems to be out of balance with how we should be approaching this issue. And finally, I would like to advocate for a necessity of defense. If someone were to commit one of these crimes like the game warden was talking about earlier, there should be an affirmative defense to say that I had to cross this land this way because there was a storm or someone was hurt or someone was sick or any number of things that may come up in the middle of nowhere in Wyoming that someone has to cross private property and they aren't doing so with criminal intent. With that, I'd love to take any questions if anyone has any.
Thank you, Mr. Tanner. Committee, any questions for Mr. Tanner? Seeing none, thank you for your testimony today.
Thank you.
And last call for public comment in the audience. Okay, seeing none. Committee, what is your pleasure? We'll go ahead and close public comment. Committee, what is your pleasure? Moved by Representative Oakley. Seconded by Representative Nymek. Amendments, discussion. Chairman Washington.
Thank you, Madam Chair. Just a couple of points in response to much of the testimony that we received this morning. All of Title 23 differentiates between hunters, fishers, trappers, and every other kind of outdoors person. So that's what Title 23 does. The whole entire chapter, and it's been that way for decades. Title 23 creates strict liability, and it has for decades. So when we talk about this bill, we know that there are so many other issues, and I'm with you when we talk about access to public lands, right? That's the underlying big issue that happens all the time. But this bill really, when we boil it down, is pretty simple. It simply talks about those cases where someone differentiating between the Attorney General's opinion, which stated that when a person intends to hunt on private property without permission, we understand that. That's already the law. But what if they're going through that land to another parcel of land on the other side? And that's what this bill's about, that traveling through to reach other lands. Should that be a trespass? And currently under Title VI, if you drive through a gate and there's a sign on it that says no trespassing, and you drive through that gate to reach land on the other side, you're already committing a Title VI trespass. Okay. The only difference I see in this bill is for those people who might be afoot and who come across the barbed wire fence way away from a gate. There is no signage there, but they're now walking across that property. But in many of the other examples we heard about, driving through your land with an elk in the back, or on your way from this property to that property, that's what this bill's about. And the game warden's still going to have to prove that you're going across that property for the express purpose of hunting, angling, trapping, and so forth. I think some of the problems that we run into with the questioning by game wardens when they encounter sportsmen afield often has to do with trying to differentiate these questions of whether we have a Title VI trespass or a Title 23 trespass. And so I think this law actually might limit some of that, although the warden's still going to have to ask questions about what's your intent? What are you planning to do? Where are you heading? And he said, well, I'm heading to that BLM land on the other side over there. And what are you going to do on the BLM land over there? Well, I'm going hunting, I'm going fishing, whatever. That would constitute a violation of this statute. But this law doesn't do some of the things that, is being suggested. It simply says that when we have a trespass, we already, that's related to hunting and fishing, we already have strict liability laws. And if you're traveling through with the intent to hunt or fish, or coming back from having hunted or fished, if you go into the door to ask permission to hunt on the property, you haven't met the elements of what this statute calls for. If you're going to the residence of the landowner to report sick livestock or a down fence line, you're not creating the elements of this crime, because you have to be going through that land for the purpose of taking wildlife or angling or trapping or something else. So I think it's real important that we stick to the language that is spelled out here in this bill.
Representative Oakley.
Thank you, Madam Chairwoman. And I just, not to belabor it, because I'm going to echo a lot of the points that our good chairman just made. But we really got knocked off track there at the end, as far as, I mean, it was said limiting access this way. Nothing about this bill could limit access, because we as a body have absolutely no authority to make laws regarding what private landowners can do. We couldn't say they can have access if they want. Luckily, that's covered in the Constitution and private property rights, which are foundational and fundamental to our country. So this is not about access. Yes, this is not, it's not in the realm. This does not and cannot limit access according to our laws and our Constitution. So you have to understand, it's very important. We, can take a lot of public testimony, but certainly for members of the committee to understand what exactly we were talking about and how narrow and how limited the bill in front of us is. And what I'd like to say is that I actually think this is perfect. This talking about this 20-year-old Attorney General's opinion. And according to the testimony or the opinion, at least of the good gentleman that testified, referring to it as vast misinterpretation for 20 years. Well, that's exactly what we're trying to do here then is say exactly what we are looking at. If just entering to hunt isn't clear as far as would that be when they're returning from hunting, or if they're just utilizing it to get where they want. You still don't get to just choose to use private land so you can go hunt or fish. So this makes it clear. That's all this is trying to do. It's been discussed. This happened in the interim too, right? And then we rounded it up and we kept it as limited to what we are actually looking at, what we're actually talking about. And then you'll notice we had broad support. We had broad support from agencies, from hunters, from this isn't corner crossing, this isn't all of these other things. And we went off track again today, and that's fine. But it's important as we look at this bill to understand how limited this is and what this does in allowing game and fish to cite for trespass on private land. And that's all this bill does.
Question being called. Okay, roll call votes on Senate File 56.
Representative Kriegel.
Aye.
Representative Chestick.
No.
Representative Haroldson. Representative Jennings. Representative Nemec.
Aye.
Representative Oakley.
Aye.
Representative Provenza. Chairman Washut.
Aye.
And Vice Chairman Rodriguez Williams.
No.
We have 4 ayes and 5 noes.
With that, Senate File 56 has failed to pass. Committee. Thank you, everybody, for being here.